Mr. Gore, some experts have argued that because the bipartisan bill describes the governor's certification of electoral votes as conclusive, a court could not review evidence that the governor's certification was incorrect and order a revision. Do you agree that state and federal courts should have authority to review the governor's certification and that any court orders amending the certification should be conclusive when Congress counts electoral votes?
Yes.
Okay, you want to say anything more?
I'm happy to elaborate on that, Senator. Those mechanisms already do exist, as I've mentioned before, for state courts and federal courts to conduct judicial review of a governor's action or inaction with respect to a certificate. The Reform Act modernizes that practice by creating the expedited federal judicial review provision and also clarifying that Congress will accept a revised certificate issued under the order of a state or federal court.
Okay, thank you. Mr. Bauer, do you agree with that?
Yes, I do.
Okay. Ambassador, you've expressed concerns that mandatory appeal of election-related claims from a three-judge panel directly to the Supreme Court could force the court to decide cases that it would just otherwise not take up. Can you elaborate on why you think that mandatory Supreme Court review could be problematic?
Reasonable minds can disagree on the question.
As you've seen on this committee?
I wish every American could see both what goes on this committee and the bipartisan start that we have here. Yes. Now it's up to the committee in a bipartisan way to move it forward. I think reasonable minds can disagree on the mandatory requirement for appeal. I know some feel very strongly about this. The case for mandatory appeal includes having the closure of the Supreme Court, resolving things, not letting it linger on the docket. Those who feel otherwise believe that there's an adequate judicial review mechanism here. And as is typically the case with the Supreme Court, it's for them to decide whether to grant cert or not. So I think this is one, as we work through all of the necessary and kind of boil down to what we had to have to feel really good about the bipartisan compromise, this is one where folks see it both ways, Senator.
Okay. Mr. Mueller, you've said in most cases related to presidential elections, whether or not the Supreme Court has discretion to hear a case would not impact whether it ultimately rules in cases that have merit. Can you elaborate on why you think that?
Sure. Yeah, this word of mandatory appeals is a little confusing, right? First off, the party has to appeal, the aggrieved party has to appeal to the Supreme Court. And then from a three-judge panel, which already happens in some campaign finance cases and redistricting cases, the Supreme Court can't refuse to adjudicate the case on the merits if it has jurisdiction. But it can summarily affirm, which it does, doesn't have to give reasons, just summarily affirms what happens below. And that functions very much like the court refusing to grant certiorari, just denying certiorari. Or if it says that there's something wrong, they're going to grant certiorari, just as they would grant and hear the appeal that comes from a three-judge panel. So I think at the end of the day, as a practical matter, there is very little difference in how the Supreme Court is going to handle these matters, regardless of the mechanism.
Mm-hmm. Mrs. Nelson, we've heard some concern that the process for assigning judges to three-judge panels, you've mentioned this, which is usually done by a chief judge for the circuit court where the court sits, might lead to partisan bias. Do you agree that random assignment of judges to three-judge panels in cases involving presidential elections would reduce the risk, or at least the perception, of partisan decision-making?
Yes, the emphasis is really on the perception and the fact that these controversies are highly fraught, and to ensure that there's public confidence in the outcome of the results, a random selection would eliminate any sense that there's been a finger placed on the scale in favor of one party or the other. And this is not to suggest that federal judges are in any way automatically biased by the party or the president who nominated them, but rather to just remove any doubt from the process when we're dealing with such a consequential electoral dispute.
Okay. Thanks. Mr. Gore, you want to respond at all?
I would just note that with respect to the appointment of three-judge courts for redistricting cases, that's already handled by the chief judge of the circuit court, and there's been no implication that that's done in a way that's unfair or biased. I think the existing mechanism is sufficient for these cases as well.
Okay. Anyone else want to chime in? Mr. Eisen?
Assignment, given the extraordinary stakes, perhaps not everyone on the panel has an equally happy reaction to recent redistricting jurisprudence.
Okay. All right.
I'll only add briefly, there can be some flexibility that might be beneficial. If a judge from Alaska is randomly assigned the case happening in Phoenix in a very short span, if it's not a hearing on Zoom, there can be some logistical problems that the chief judge could have the flexibility to resolve in such cases. But again, this is a technical issue to think about.
Okay. Well, I think that's a good way to end because it's people are being very practical, which I appreciate, and we've had witnesses that come from different political perspectives, just like this committee has come together on a number of issues, and just like the bipartisan group has. So I want to, first of all, thank my friend, Senator Blunt, and the members of the committee for an incredibly productive hearing. I also want to thank Senators Collins and Manchin for their work in bringing a group together. I want to thank Senator King, who's been out front on this issue from the very beginning, and the two of us worked together on it, and his expertise on this, I don't think we'd be where we are without him. I want to thank Senators Warner and Capito, who's part of the group as well. And we have heard today about the ambiguous provisions in that old 1877 law that were actually exploited. I mean, you can use more dramatic words, but exploited in the last election and underscored the need to update the antiquated law. And I also think it's just a recipe for future problems, as people have now contemplated how they could mess around with it in various ways, including just kind of practically delays, objecting to multiple states. I don't think I'm telling anyone a secret. They could go on, as Senator Blunt and I before the insurrection contemplated in the range of 24 hours, but it could even go longer, and to see if any of those senators just kind of, get sick or something. Can't be there. You start having all kinds of issues come up, and that's why I think that practically looking at it, no matter where you come from politically, there needs to be changes. We heard bipartisan agreement that we need to reform the Electoral Count Act to secure the peaceful transfer of power. We've talked today about the role of the vice president, which cannot be used to overturn the will of the people. We've talked about how you can certify a slate and make sure it's the actual electors and not something that's added fraudulently at the end. And we've talked about this appeals process and how we can get that set so that makes sense. And I appreciate, again, this work on this bill to provide much-needed clarity to the Electoral Count Act. And I would just add, with Ms. Nelson there in the distance on the screen, just that there are a number of us that are still devoted to putting some sensible federal rules into place to make it easier for people to vote, because that's what we should be doing in a democracy. That's what the Freedom to Vote Act is about. The Hearing Act, I'm going to let Senator Blunt, do you want to say a few words here at the end?
Well, thank you, Chair.